Hi, everyone. Thanks so much for joining us for this webinar provided by the Justice for Immigrants campaign of the U.S. Conference of Catholic Bishops. My name is David Spicer. I serve as Senior Policy Advisor with the Department of Migration and Refugee Services at the USCCB. We're joined today by a fantastic group of panelists who will be walking through this topic, resettling special populations, striking the right balance between urgency and equity. I'll start off the webinar by introducing our panelists, and then we'll get right into it. So first we have Lacey Bromell, who is policy analyst with the International Refugee Assistance Project. We also have Kristen Lionetti, who serves as the U.S. liaison for the International Catholic Migration Commission. And then last but not least, we have Colleen Teif, Associate Director of Processing Operations for the Department of Migration and Refugee Services at the USCCB. Each of the panelists will be talking about aspects of this subject matter related to their own work with their respective organizations. To begin, I'll give a brief introduction about this topic and what it is that we're here to discuss today. As the title suggests, we are discussing the subject of special populations, so to speak. This is by no means a formal phrase within sort of the parlance of the refugee resettlement program or the sort of US immigration system, but it is a phrase to describe a few populations that in recent months and in recent decades have benefited from a sort of prioritization of humanitarian resettlement in the United States. So, we have a few historical examples here that I've listed. We have Cubans, and each of these I'll note are sort of related to a significant event that has occurred. In the case of Cubans, it would be the Cuban Revolution. In the case of Vietnamese, it would be the war in Vietnam. Following that, we have citizens of the Soviet Union, or in some cases, the former Soviet Union, depending on when it is those individuals entered the United States. We have Iraqis following Operation Desert Storm. And then finally, we have Kosovans in the late 1990s. In each of these cases, we saw a response from the United States government that resulted in large numbers of members of these nationalities being relocated to the United States. Many of those individuals resettled in the United States permanently. Some would go on to return to their countries of origin, but in each of these cases, there was a demonstrated effort on behalf of the United States government, and American communities to welcome people who were fleeing conditions in their countries of origin that made it difficult, if not impossible, for them to remain there. Even more recently, of course, we have a couple of noteworthy examples, and not only more recently, but ongoing. One of those examples is Afghans. Following almost 2 decades of US military intervention in Afghanistan, Kabul came under Taliban control in August of 2021, and it was around this time that the US military organized an evacuation of more than 120,000 people, including over 70,000 Afghan nationals. The vast majority of these Afghans were admitted to the United States using a mechanism in US immigration law known as humanitarian parole, and they were provided that parole for a duration of 2 years. And this took place over the period of about 6 months, a little bit less for the majority of those 70,000 Afghans. And even now we have a number of Afghans who are being relocated to the United States as part of what's known as Operation Allies Welcome. Just to provide a bit more insight into humanitarian parole, it is a temporary measure to allow people to be authorized to enter the United States and to remain here. It is not a status such as immigrant or non-immigrant, but it is, again, a temporary authorization, and it allows people to bypass normal entry requirements, such as having a visa, as a result of a humanitarian or public need for that person to enter the country. So in most of these cases that we'll discuss, and most of those that I've mentioned already, it was very much a humanitarian justification for parole to be granted. And so that is very much the case for this next example, which I'm sure many of you are following very closely, and that is the resettlement of Ukrainians who are fleeing the military invasion of Ukraine, which began in February of this year. On March 24th, the Biden administration announced that it will work to welcome up to 100,000 displaced Ukrainians to the United States. On April 21st, the administration then announced the creation of what's now known as Uniting for Ukraine. And this is a streamlined process for displaced Ukrainians seeking to enter the United States, either permanently or for a temporary period of time. But importantly, the program does rely on humanitarian parole, which, as we discussed just a moment ago, is a temporary measure and would only provide authorization for these individuals to be in the United States for 2 years. This period of time can vary, but for the most part, it'll be 2 years for this population, as was the case for the Afghans. It does require that each Ukrainian beneficiary have a US-based fiscal sponsor. So this is an individual or a family or an organization that would commit to the financial well-being and support of each Ukrainian who is relocated to the United States as part of the Uniting for Ukraine initiative. And this varies quite a bit from the experience of refugees who are resettled under the US Refugee Admissions Program, which we'll get into in just a bit with the presentations of our other panelists. I do just want to put into perspective here the significant the significant difference between these populations, the Afghans and Ukrainians in particular, and the populations that have been resettled over the past 5 years through the Refugee Admissions Program. We saw on the previous slide here, over 70,000 Afghan nationals were brought in through Operation Allies Welcome, and the expectation here is that we could see up to 100,000 displaced Ukrainians through Uniting for Ukraine, as well as a variety of other pathways that could very well include the Refugee Admissions Program. Now, this chart here shows that in the past 5 years, we have seen even fewer between all 5 regions of the Refugee Admissions Program than what we are seeing for either of these populations resettled over a period of months. Certainly in the case of the Afghans, it could be longer than just a few months in the case of Ukrainians. But I have here each of the different regions that are sort of used for the Refugee Admissions Program from fiscal year 2018 all the way up until most recently March of this year. And you'll see in the regular course of the Refugee Admissions Program, the highest number of refugees came from Africa, and that number only reached 41,000. So we doubled that almost with the number of Afghans who were resettled. And this is what we're talking about when we say special populations and the urgent need or prioritizing based off of urgency. So now we're going to move on to Lacey with IRAP to give us more about the framework of the Refugee Admissions Program and the international laws applying to refugees.
Thank you so much, David. It's really nice to be here with you all today. My name's Lacey Bromell. I'm a policy analyst at the International Refugee Assistance Project, or IRAP. And I'm going to be taking us back for a little history lesson to give you some background on the US and international legal frameworks that were created over the last century that today still form the basis of protection for refugees. And then I'll be offering a perspective on how those frameworks are responding to the questions of urgency and equity today. So today's US Refugee Admissions Program, or US RAP, and the International Refugee Protection Scheme is rooted in post-World War II commitments to responding to the millions of displaced people in Europe at that time. And before that time, there was no formal or specialized entry for people fleeing persecution. So it really took several decades, as you'll see from the screen, and I'll sort of walk through each of these actions that took to build up these pathways and protection measures, specifically for people fleeing persecution. So in the United States in 1948, Congress passed the Displaced Persons Act, which authorized the entry of 200,000 displaced persons over 2 years. And it established a displaced person commission that was meant to work with faith groups to resettle these people. So early on, a reliance on faith and civil groups to ensure refugee integration and welcome in the United States was a significant part of our program. Then in 1951, nations from around the world gathered to develop the 1951 Refugee Convention. This is a United Nations multilateral treaty that defines who is a refugee, and it also sets out the rights of individuals who are granted refugee or asylum status and the responsibilities of nations towards those individuals. So, keywords I'm going to come back to a couple of times here are rights and responsibilities. And initially, the 1951 convention was more or less limited to protecting European refugees, but the 1967 protocol relating to the status of refugees expanded that geographic limitation. So both the 1951 Refugee Convention and the 1967 protocol, in addition to a couple other global legal instruments since then, continue to serve as the bedrock of our refugee protection system today. Starting in 1975, so turning back to the United States, the US resettled hundreds of thousands of Southeast Asian refugees, of course, the majority of them Vietnamese, through an ad hoc refugee task force that had temporary funding at the time. That experience prompted the United States Congress to pass the Refugee Act of 1980. This incorporated that UN definition of refugee, and it standardized the resettlement services for all refugees admitted to the United States, and it established the Office of Refugee Resettlement, which I'm sure many of you on the call are familiar with today. And so the Refugee Act provides the legal basis for the United States, our refugee resettlement program, and our response to refugees globally. Next slide, please. Now that you know the history, what's the definition of a refugee and what are those rights and responsibilities that I was talking about? So in the United States context, a refugee is a specific legal definition that's based in that Refugee Act of 1980. It's someone who's located out of the United States, is of special humanitarian concern to the US, someone that has to demonstrate that they've been persecuted or have a well-founded fear of persecution due to their race, religion, nationality, political opinion, or membership in a particular social group. They also must not be already firmly resettled in another country, and they have to be admissible to the United States. Under the legal frameworks that I mentioned, refugees possess specific rights. So if you meet this categorization, you've been defined as a refugee, you have specific rights. You have a right not to be forcibly returned to your country of origin. You have a right to housing, to education, to work, and more. And states, through this UN international framework that I was defining, they have specific responsibilities to protect those rights and to also take action to work together to protect refugees. And refugee resettlement, which we'll be talking about a lot today, is one specific way that states, and especially the United States, complete that obligation to support refugees around the world. So go to the next slide, and then I'll talk a little bit about refugee resettlement here. So in order to be resettled to the United States, a person has to be defined and meet that definition of a refugee I just mentioned, and then be referred to the US Refugee Admissions Program. Then they must undergo a multi-step screening process. This includes an in-person interview by a trained officer. It includes extremely lengthy and oftentimes overly burdensome security vetting. And only then is an individual approved to be resettled to the United States. And please note that this process can take years. Once someone is admitted and resettled in their new home in the United States, they're eligible for certain time-limited benefits and assistance upon arrival. Then that individual can apply for a green card and eventually citizenship after 5 years. Kristen and Colleen will be discussing some of the challenges around equity and urgency in those aspects of resettlement later in the webinar. So we'll get really in the weeds on this. So don't worry if this is new to you. So on the next slide, what I want to talk about now is that the US refugee resettlement system operates on those frameworks that I mentioned. And it's now been 70 years since the 1951 Refugee Convention and 42 years since the US Refugee Act of 1980 were established. And I think it's fair to say that there are questions about how this protection structure is working for the people it intends to protect and support. There are questions like, does the current definition of a refugee apply to the conditions forcing people to flee today? Is the law being applied evenly to everyone, no matter their religion or their nationality or identity? And are other states upholding, or states generally upholding their responsibilities to protect? So I offer to you today that while these frameworks have certainly done much to provide support and life-giving opportunities for refugees, I think we can say that these frameworks are fragile. In 2016, the UN did agree on a new global compact on refugees that recommitted states to new and dynamic approaches to refugee protection. But yet still, there is unevenness in the application of the law protecting refugees and in the way that states do or don't uphold their responsibilities to refugees. So I'm going to point to 4 primary areas related to this to give you some examples. The first is about the definition of a refugee. The definition of a refugee was created in 1951, as you now know. And does that definition recognize all the ways people are forced to flee in today's world? For example, climate-related pressures and disasters are on the rise and are increasingly driving people from the places that they call home. In fact, some estimates say that the changing climate is going to displace more people in the coming decades than conflict or other factors. Yet there are no multilateral treaties or US domestic laws specifically covering climate displacement. IRAP and others are actively engaged in advocating for ways to identify climate displaced people and to create options for their protection and resettlement. The second issue is a question about political will to protect refugees. This gets back to that word, responsibilities. It's up to states to enact certain protections, but so often we see states completely ignore refugee rights. These decisions are often tied to a nation's political or foreign policy decisions that frankly are sometimes out of line with the realities of humanitarian need. Right now, for example, we're seeing differences in the ways that Ukrainians are being treated versus refugees from other countries in the media and by policymakers from around the world. I know that IRAP believes, and I know that most of us on the call agree, that accessible and effective programs to get people out of danger to safety, like we've seen with Ukrainians, should absolutely be the norm and not the exception. A third significant area of concern for urgency and equity is related to protracted refugee crises. A protracted refugee situation is one in which more than 25,000 refugees have been in exile for more than 5 years. And it's currently estimated that some 15.7 million refugees, or 76% of all refugees, are in a protracted situation at the end of 2020. And when the US and international frameworks were developed decades ago, I don't think that the people that created those understood or foresaw that wars and other displacement crises would last as long as some do now. This is a huge concern because while many of these crises may not be on the nightly news here on your TV in the United States, the refugees living in these situations are desperately in need of urgent solutions. And in protracted refugee crises, refugees are often denied access to work or to education, and of course, their basic health and livelihood suffers. So much work needs to be done to end conflicts and to ensure all refugees, whether they're living in an emerging or protracted crisis, have access to their rights and to a protection solution. The final point that I'll make here is, while I mentioned concerns about protracted conflicts, there are also certain constraints to addressing emergencies as they arise. The US and other countries have a great need to be nimble and show flexibility in crisis, but oftentimes struggle to do so. Ukraine and Afghanistan are really strong examples of that the US resettlement program currently is lacking in resources So it isn't able to be providing solutions to these emergency protection systems. So the United States has been relying on humanitarian parole, which David mentioned. So this last point is a question that, frankly, we are seeing happen in front of our eyes right now. Does our laws, does our resources in the systems that we have, are they able to be responsive in an emergency way? And Colleen and Kristen are going to be discussing much more detail about how Ukraine and Afghanistan, how this question about urgency really impacts questions of equity. So I'll leave it there for them to get a little bit more into detail at that point. So just in conclusion, I hope I've showed that there's great promise and potential in our current US and international frameworks, but there's much improvement that's needed at this time. So I will go ahead and give it over to Kristen, and thank you very much.
Great, thank you so much to USCCB and JFI for hosting this webinar and for the invitation to participate. To David and Lacey for the really helpful background to help frame our discussion today. My name is Kristen Leonetti. I'm the head of ICMC's US Liaison Office in Washington, DC. And if you're not already familiar with ICMC, it's a network of Episcopal conferences responding to the needs of migrants, refugees, displaced populations around the world. So USCCB is our member organization here in the US. We also work with other Episcopal conferences around the world that are similarly responding to the needs of displaced populations. And additionally, ICMC provides direct assistance through programming in humanitarian assistance, protection for vulnerable populations. We deploy experts to support the surge needs of UNHCR and UNICEF. And we carry out the overseas processing of refugees. Currently for the US's program, the US RAP out of Turkey and Lebanon, and we've played a similar role in other locations previously. So I'll primarily focus on a little bit of background and perspective from that lens of overseas processing. But before we go into that, I wanted to just zoom out a bit to the scope of global needs to remind ourselves of the people that we are working to reach through the policies and legal frameworks that Lacey has just described to us. So as you can see here from the figures that are on the screen from UNHCR, the needs are extraordinary, right? We have 84 million forcibly displaced, 26.6 million are refugees, an additional 48 million internally displaced within their own countries. And I think there's a few things here that I wanted to be sure to note, in addition to the needs just being extraordinary. In 2020, it was far under 1% of refugees globally that were actually resettled. 39% of refugees globally are hosted in just 5 countries. In Turkey, where ICMC operates its resettlement support center for overseas processing, hosts the largest number of refugees in the world at 3.7 million. And so I think it's good for us to just be aware of that. And also, you can see the next point on here is 85% are hosted in developing countries. So just to keep in mind that the majority of those that are displaced globally, we don't see resettled. The vast majority we don't see resettled. And then lastly, though it's probably clear, even though these needs and the levels of displacement are at historic highs, is that they're on the increase, right? There's an upward trend in recent years. And at the same time, and if we can go on to the next slide, please, David. If we take a look at the US RAP and the US's program, we see the inverse. While global needs are increasing, instead of keeping pace, we see a downward trend. I won't go too far into details with the figures that are reflected here on the screen. The blue line shows the ceiling or the presidential determination, and the orange, the number of refugees admitted. But you can see, of course, that this trend is not exclusive to the last few years. It's been declining previously as well. But if you take a look at that red box that's to the right of your screen, which reflects these last few years here, you can see that we are at the lowest levels since the creation of the program. And of course, this has to do with some of the policies of the previous administration, which reduced that ceiling, reduced resources, had strong impacts on the staffing of the various entities that are engaged in making the program work, allowing it to function. And at the same time, of course, we've also had COVID, and that has had some very real impacts as well for the program. Of note, I would call your attention to the fact that the USCIS officers were not able to travel to the field to conduct and carry out interviews in order to be able to adjudicate cases for a long period of time. So that has related, has been kind of translated into processing delays for the refugees that are in the program. Of course, we're glad to see the increased commitment to resettlement in some of the more recent policies, specifically the higher presidential determinations, the increase in resources, that investment in the program, and the executive orders that were introduced early on in the current administration that really call for looking at where the program has bottlenecks and where we can find greater efficiencies to accelerate processing. But to be honest, we're still waiting to see the results of those improvements. I think it is important that we continue to push for the rebuilding of the program. That includes the resources, that includes the staffing, and some of that staffing is already happening for the government entities that contribute to the program, as well as for entities that are carrying out the overseas processing and the domestic resettlement. My colleagues in Turkey would ask me to flag that doesn't happen overnight. And as many of us know from our experiences in other organizations, even if you hire for a vacant position, staff turnover takes time, and you've lost some learning and some institutional experience with the departure of those staff. So that's part of what we find ourselves in now. If we can go to the next slide, I wanted to touch on what overseas processing for the US RAP typically looks like. And this is that same visual that you saw from Lacey a few minutes ago, but really we're concentrated on that first square. So the US government contracts various organizations to support its overseas processing. That's through 7 what are called RSCs, the Resettlement Support Centers globally. As I had mentioned, ICMC operates the RSC that is out of Turkey and Lebanon. And so that I'm just seeing questions here, sorry. So that includes, as Lacey had touched on, receiving referrals from UNHCR, case processing, which would include collection of data, case information, photos, coordinating the logistics for when USCIS carries out what's called circuit rides, or when they send officers to the field to interview cases and to fingerprint, supporting the process of medical screenings and providing cultural orientation before refugees would depart from Turkey or Lebanon to the US. So I just want to take note quickly that already years back, it was taking, as Lacey had mentioned, a couple of years to process, or multiple years to process. And so the processing delays that I highlighted on the last slide have only increased this. The couple of years have become longer in that time. So for us at the RSC and for me here in Washington, it's not uncommon for us to hear from individuals or their loved ones regarding cases that were referred and pre-screened years ago. And if we can go to the next slide. regarding expedited models. So quickly to say that we would expect some of the special populations that David had previously spoken about, Afghans, Ukrainians, to be processed through the RSCs that I just talked about, if those individuals are in those locations. And I'll say that the decisions around who to prioritize which cases are not made by the RSCs. So not made by ICMC or by the other organizations that operate RSCs in different parts of the world. Those are decisions that are really made by the US government. But I wanted to touch also on these expedited models that have already kind of been explained in terms of how we can respond more quickly to crises and critical needs that clearly arise, and to what that's looked like in these couple of instances. So I won't spend as much time talking about humanitarian parole, since David already touched on that, and I know Colleen will speak a little bit more about what some of the implications are for it on the US side once people arrive. But I did want to mention an expedited processing model for Afghans that the US government has put in place and is kind of in the process of putting into place and ramping up, trying to implement. So through that model, it would process Afghans within a window of 30 days is the goal. That's taking place on a US airbase in Doha. Individuals could be processed as refugees or as SIV holders, and this would allow them to enter the United States with that status rather than entering on humanitarian parole, as David had described previously. So the vision here is for the processing to take place more quickly and to be responsive to the critical needs that we are seeing. But the idea also, as we understand it, is to see what learning can be and what tweaks can be applied more broadly to benefit processing in other parts of the world, and potentially through other kind of processes and workflows. So, I think it's too early to have heard a whole lot about how that's going and what implications it will have, but that's been the hope that's been expressed to benefit some of the other populations that have been waiting. But as you can see, 30 days of processing is a lot different from several years, the several years that we just spoke about. And if we can then go to the next slide. In terms of our reflections a bit on urgency and equity, I think first just to convey that, of course, we're concerned for all displaced populations. And of course, we recognize the urgency that's really required to respond when critical needs arise, such as has been the case in Afghanistan and in Ukraine. So we're glad to see those commitments of, opportunities to access protection and to flee the country. And we're also concerned for the many who have already been displaced for years. Again, I would note every day I receive calls and emails from refugees who have been waiting already for several years. Their case has been in processing, or from their loved ones wondering why the cases aren't moving. And particularly when they see announcements such as those that the administration has released around special populations and the expediency with which their cases will be processed. Many of them live in highly vulnerable situations without assistance to meet basic needs or to access services. A lot of them have really difficult times accessing livelihoods in order to support themselves, and they're doing that for years while they wait. So just as we reflect on this question of what does it mean to respond with urgency and also with equity, I think it's worthwhile for us to take into consideration their point of view, to step into their shoes a bit and imagine what it looks like to them when they see other populations being resettled in significantly shorter times. And I will pause there for now and turn over to Colleen. Thank you.
Sorry about that. Can you hear me?
You're good, Colleen. Thanks.
Great. All right. Good afternoon, everyone. My name is Colleen Tai, and I'm the Associate Director for Processing Operations in the Office of Resettlement Services at USCCB. USCCB is one of the 9 national resettlement agencies contracted by the Department of State to provide reception and placement services to newly arrived refugees and SIVs through our respective affiliate networks. So today, I'm going to talk about the use of humanitarian parole versus the U.S. Refugee Admissions Program as a means of addressing large-scale displacement and some of the benefits and limitations to each pathway. I'll discuss this in the context of the very large numbers of Afghans who were resettled over the last 8 months and some of the unique challenges this group faces given their entry to the U.S. under humanitarian parole and not as refugees. I'm also going to talk a little bit about the U.S. Refugee Admissions Program and how the program desperately needs to be rebuilt and made more efficient, and how entering the U.S. as a refugee is ultimately a more favorable option for the resettlement of displaced persons. So as you can see on this slide, talking about the benefits and shortcomings to humanitarian parole. So as already mentioned, instead of making use of the U.S. Refugee Admissions Program to provide U.S. entry to large groups in need of resettlement, the Biden administration has relied heavily on the use of humanitarian parole to offer protection to those facing harm. As my fellow panelists have already mentioned, the U.S. government has relied on humanitarian parole to resettle approximately 70,000 Afghans, and it is also using it to resettle large numbers of displaced Ukrainians under the new Uniting for Ukraine initiative. So I want to discuss some of the benefits and drawbacks to both humanitarian parole and refugee resettlement and why the U.S. government is making use of humanitarian parole. So the number one greatest benefit to humanitarian parole, and the main reason why the U.S. government is relying on it to resettle displaced Afghans and Ukrainians, that it is a highly efficient way to provide urgent, large-scale resettlement to those facing harm. If you look at the Afghans arriving under humanitarian parole, they were initially evacuated to U.S. military bases, or what we call lily pads, in the Middle East and Europe, where they underwent security vetting as well as some basic processing before arriving in the U.S. under humanitarian parole. This enabled the U.S. government to relocate very large numbers of Afghans in just a few weeks or less. In some instances, it was just days. However, there are a number of drawbacks to relying on HP for refugee resettlement, individuals who, are likely to resettle here, at least temporarily, or if not permanently. So for one, humanitarian parole typically does not offer the same benefits as those entering the U.S. as refugees. So fortunately, through an act of Congress, the U.S. government did authorize benefits to Afghan parolees admitted under Operation Allies Welcome. Due to this exception, Afghan parolees are eligible for traditional refugee resettlement services as well as public benefits, including healthcare. As with refugees, this has enabled Afghan parolees to be served by local refugee resettlement affiliates who are responsible for providing housing, case management, employment services, language services. All other individuals who entered the U.S. under humanitarian parole are not eligible for refugee resettlement services as well as public benefits. And this also includes the Ukrainians who will enter the U.S. under Uniting for Ukraine initiative. They will not have these initial services nor public benefits. So those who arrive, who enter the U.S. under humanitarian parole, are not automatically work eligible. They must apply for work authorization after they arrive, and they will also have to pay a filing fee to apply. And this can delay their ability to work for months. So this can be a great financial hardship to those without financial means or US-based support. Perhaps, and my colleagues have spoken about this, but perhaps one of the biggest drawbacks to humanitarian parole is it does not offer a permanent status to legal immigration. which I will discuss this a little bit more later in the context of the Afghan parolees. Another drawback is that it adds to the massive asylum backlog for those seeking permanent status. Currently, there are over 1.7 million pending asylum cases with processing times averaging 4.5 years. Using humanitarian parole to allow large-scale entry for those who should more appropriately be admitted as refugees only delays processing for those who've been waiting for many years for their asylum cases to be adjudicated. And lastly, those who are paroled into the US without their immediate family members don't have any mechanism for family reunification. And again, I'll talk a little bit more about this under the Afghan context. So next slide, please. So if we turn to the refugee admissions program, you'll see that one of the benefits of entering the US as a refugee is that it provides a pathway to citizenship. So again, they've already been adjudicated overseas. They enter the US under the status of a refugee. And by doing so, they can apply for lawful permanent resident status after being in the US for at least 1 year, and they can apply for citizenship after 5 years. Another benefit is that refugees can legally work as soon as they arrive in the US, so there's no delay in that aspect. They are also immediately eligible for public benefits, and all refugees receive support from an affiliate agency, which provides initial resettlement services to set them up for success. And then lastly, resettled refugees who have been separated from their family have several different options for filing on behalf of qualifying family members for US entry. And they immediately can apply for family members after they arrive in the US. Next slide, please. So let's look at this under the context of the nearly 70,000 Afghans who entered the US under humanitarian parole since September 2021. So while it's certainly commendable that the US government is fulfilling its moral obligation to protect Afghans who supported the US and the US interests in Afghanistan over the last 20 years, making use of humanitarian parole for large-scale emergency response has come with a myriad of challenges. For one, the large-scale evacuation and subsequent resettlement of Afghans has placed an enormous strain on the existing refugee resettlement network. The influx occurred in the aftermath of the Trump administration, while whose policies resulted in approximately 135 affiliate office closures, as well as large-scale layoffs, staff layoffs for the agencies that remained. While efforts were being made over the last year to rebuild the resettlement capacity, the existing resettlement network was by no means well equipped at the start of September of 2021 to deal with such a large-scale resettlement effort. Because of this, the resettlement of Afghans to their permanent communities was delayed. So upon arrival to the US, Afghans were temporarily housed at US military bases, which were called safe havens, where they underwent further processing and waited for a local resettlement agency to what we call assure, which is essentially to sponsor their case. So due to the lack of resettlement infrastructure, many Afghan families had to wait as long as 4 to 5 months in sometimes extremely unfavorable living conditions at safe havens before finally being resettled by an affiliate. At the same time, affiliates were extremely overwhelmed by the sheer numbers of arrivals. This has undoubtedly had an impact on the level of individualized care and quality of case management that resettled individuals typically receive under normal resettlement circumstances. And despite having a mechanism in place to expedite processing of Afghan documentation, because this was sort of a new program that was set up overnight and new processes, there were significant delays in the provision of Social Security cards and work authorization documents for Afghan parolees. Given these delays, many Afghans were not eligible for public benefits and employment for many months after their arrival. And this caused an even greater strain on the affiliate agencies who are responsible for their material well-being. Housing has been an enormous challenge. As many of you are aware, available housing became very scarce and rent prices soared during the COVID pandemic. Given the lack of available housing, most affiliates had to place Afghans in hotels and other temporary housing for weeks and sometimes months. The documentation challenges only added to the delays in finding permanent housing, since many landlords require a social security number for a lease application. So including their time spent on safe havens, many Afghans have been in temporary living situations for 6 months or more. And the upheaval and lack of permanency in the resettlement of an already traumatized population has created even more stress for many Afghan arrivals. It has also created challenges and delays in school enrollments for children as well. Another major challenge Afghans face is family reunification. In the rush to evacuate, thousands of Afghans left behind their spouses, children, and parents. And some 1,400 Afghan minors arrived without a parent or legal guardian. As mentioned earlier, there is no mechanism for family reunification for those who gain U.S. entry through humanitarian parole. Unlike refugees and SIVs who can file for their parents, spouses, and unwed minor children immediately after they arrive to the U.S., parolees cannot file for their family unless or until they have been granted asylum or SIV status. This has caused great stress for many resettled Afghans who worry about the safety of their family back in Afghanistan, yet there is no existing pathway or mechanism for family reunification. Some individuals have not been able to cope with this and have actually chosen to return to Afghanistan to be with their loved ones. So the next major challenge Afghan parolees face is adjusting their temporary status to something more permanent, either through asylum or SIV status. However, both of these pathways are challenging and backlogged. In putting tens of thousands of Afghans through complicated individual SIV and asylum determinations will be incredibly burdensome, not only for the applicants, but for the US government and for legal and resettlement service providers. Most Afghans are likely to be in legal limbo for long periods, and many Afghans might not succeed in their SIV or asylum applications, which will only cause even more uncertainty for their futures. So while the quick response to meeting the protection needs of highly vulnerable Afghans was certainly the right thing to do, humanitarian parole is far from an ideal pathway and has created many unnecessary challenges for vulnerable Afghans. I just want to make a few quick remarks about the US standing up the Uniting for Ukraine program, and what kind of the implications are for that. While again, it's commendable that the US is responding to the crisis, there are concerns about the use of humanitarian parole and the structure of the program for US admissions. So for one, it provides a pathway to the US only for those with US-based sponsor. So it does disqualify others that may be in need of protection because they will need a US sponsor. They will be admitted under a temporary status that does not allow for permanent resettlement. What happens if the war drags out for many years? And what if the cities these Ukrainians have come from were completely destroyed and there's nothing to return to? It would be more favorable to create a legal pathway that would allow for greater permanency for those who wish for it, or maybe not. Those admitted under Uniting for Ukraine will generally not be eligible for public benefits, including health care. It will therefore dissuade the most vulnerable, those who cannot work or who have special medical needs, from utilizing this program. It'll be interesting to see, it remains to be seen how quickly these individuals will be processed. If there is great interest, it likely will result in processing delays and therefore not an ideal response to an emergency situation. So I just also want to quickly talk about the US refugee admissions program. As my colleagues have shared, unfortunately, the program has not made significant improvements in efficiencies or in rebuilding the program over the last year. So although the presidential determination for refugee admissions is 125,000 arrivals for this year, only 10,300 refugees have arrived to date, and we are already 7 months through this fiscal year. So we're not going to come anywhere close to the 125,000. And again, while it is not my intention to minimize the need for resettlement for vulnerable Afghans and Ukrainians, let us also not forget that there are literally thousands upon thousands of highly vulnerable refugees of other nationalities who've been caught in the US resettlement pipeline backlog for decades, for years. These are individuals from Syria, Sudan, Burma, Democratic Republic of Congo, Somalia, Iraq, Iran, and Ukraine, among many other nationalities. The P3 family reunification program has been particularly impacted. These cases are subject to additional processing requirements, and as such, P3 cases have languished in the pipeline for many, many years. Instead of relying on humanitarian parole to resettle a few select nationalities in need, the US should be rebuilding and making use of its resettlement program to resettle all nationalities, including Ukrainians and Afghans. And so, as Kristen has mentioned, the US government is currently conducting 30-day expedited processing of Afghans overseas in Doha. These individuals are entering the US as refugees and SIVs and are afforded all the benefits under the Refugee Resettlement Program. The US should make every effort to expand this method of processing to other nationalities equally deserving of resettlement and a promising future. So now I am going to turn it over to David, who can offer some thoughts on, I think, for Ukrainians and Afghans in terms of more permanent legal status.
Thanks so much, Colleen, and thank you, Lacey and Kristen, for all of your really strong insights and the expertise that you have to share. I did just want to talk a moment about addressing some of the inequities that we see produced by urgent responses to some of these refugee crises, and in particular, as we saw with Afghans, and now we're seeing with Ukrainians, and continue to see with Afghans, I should say. Our great panelists have pointed out some of the disparities that exist between those who enter the country with parole, humanitarian parole, and those who enter the country with refugee status through the refugee admissions program. Because of the distinctions in those two mechanisms, you have different options available to parolees versus refugees, and even further, those who are able to be those who are granted asylum have different options available to them than both refugees and those with humanitarian parole. So in the case of Afghans, for example, we did hear that Congress authorized members of this population to receive the same services and benefits as refugees who were brought in through the refugee admissions program. However, that didn't go so far as to provide them a pathway to permanent legal status, and then if they were to choose in the future to pursue naturalization and become US citizens. So that's why the US Conference of Catholic Bishops, together with our friends at IRAP and all of the resettlement agencies and a wide variety of other organizations, have called on Congress to pass an Afghan Adjustment Act, which is legislation as it's envisioned that would create a streamlined process for Afghan parolees to apply for permanent residency, and as I said, later pursue naturalization if they chose to do so. This would be a way to rectify the inequity that was created by this very well-intentioned and, of course, commendable response to Afghans in need following the end of the military intervention in Afghanistan. At the same time, we've seen, as Colleen and others have mentioned, that there is a very real consequence to not having the same access to services and pathways, and we're anticipating this possibly being the case with Ukrainians. So the USCCB and others, including IRAP, I believe, have also called on Congress and the administration to ensure that Ukrainians who are resettled or who temporarily come to the United States through this Uniting for Ukraine initiative have access to those services and can fully integrate into American communities if they choose to do so and they don't have the ability to return to Ukraine, given whatever circumstances might transpire between now and hopefully sooner than later, the end to the conflict that's ongoing there. So there is a very real need for Congress to act, and that is why we have called for these measures to be taken. And again, this is as a result of good faith and intentions and efforts to resettle populations that are in urgent need, but also as those here have stated, it underscores the need to improve and to expand and to really put robust resources behind the refugee admissions program and to modernize it so that it's capable of responding to urgent situations like what we've seen with Afghanistan and as we're seeing with Ukraine. So that is sort of the gist of what we hope to cover today. We are happy to go through some of the questions that we received. I know that we've gotten a couple in the chat here. I've addressed one. I think we do have one from earlier on in the webinar, and I don't know which of our panelists would be best positioned to address this, but it looks like Sharon asked about Africans going to Canada because they have more assistance there and what additional assistance that might be. So in talking about equity and sort of the options that are available to those who are resettled in the United States, I guess another example of equity or inequity could be what's available to refugees in the United States versus other countries such as Canada. So Lacey, Kristen, Colleen, I don't know if one of you have any insights into the resettlement benefits that are provided to refugees in Canada, but by all means, if you have anything to share there.
Yeah, thanks for the question. And I unfortunately can't speak with a lot of detail about the specific benefits that are provided there. I will say, I think one thing that we hear on the overseas side of things is refugees wondering if they were referred to another country's resettlement program, if they might access protection sooner, or potentially with other benefits as well. But just to note that we have had some cases where cases are discontinued within the US RAP because they're able to access something somewhere else, and that's of course understandable.
Thanks so much, Kristen. One other, go ahead, Colleen. I see you came off mute.
I also cannot speak with authority about the Canadian model of resettlement, but I do know they rely much more heavily on community sponsorship rather than strictly government support. And I know that they have several different models of resettlement. And one of them, where it's more pure community sponsorship, allows for 12 months of support, whereas in the US, the reception and placement program is only up to 90 days of support. I believe they overall, US resettlement numbers historically have been much larger, but there are programs in Canada that can offer greater support.
Thanks so much, Colleen. It looks like we did have a couple of other questions here. One related to the humanitarian parole granted to Afghans versus the humanitarian parole to be granted to Ukrainians, and I can go ahead and address this one quickly. It is the case that generally speaking, the humanitarian parole provided to Afghans over recent months is the same being provided to Ukrainians. It could be the case from one individual to the next that there are varying conditions based off of when the individual enters at a port of entry, whether that's an airport or somewhere else. This is done on a case-by-case basis by Customs and Border Protection and the other agencies within the Department of Homeland Security that are authorized to grant parole. But for the most part, again, it's a temporary authorization to be in the United States. It makes people eligible for work authorization, which they would then have to apply for. And then aside from that, it doesn't provide too many benefits or access to services in comparison, again, to refugees and those who are actually granted asylum. Ukrainian parolees could pursue asylum, just as Afghan parolees have been expected to do up to this point. And then if granted asylum, they would become eligible for a more robust array of services and benefits and legal pathways. And again, there is a distinction between Afghan parolees and Ukrainian parolees because Afghans were authorized by Congress to receive the same services as refugees, sort of on a very intentional basis, whereas up to this point, we haven't received any indication that Ukrainian parolees would receive that same sort of authorization from Congress. But it could certainly, could happen. We just don't yet have the expectation that that will be the case. And then the second question asked was regarding the delay in the government's publishing of the Federal Register notice for the temporary protective status designation for Afghanistan. I did, as soon as I saw that question, I did look up the dates. So the designation for TPS, temporary protected status, for Ukraine was announced on the 3rd, and then the Federal Register notice was published on the 19th. That is, of course, about 16 days. The announcement for TPS for Afghanistan was announced on the 16th, so we're still not quite 13 days from then if we are to expect the same sort of timeline that we saw for the Ukrainian TPS designation. Oftentimes, there's a bit of a delay between the announcement and the Federal Register notice publication, and that varies from one TPS designation to the next. So I don't know if Lacey has anything to add on that front in terms of distinctions and TPS designations and the actual Federal Register notice publication and sort of the questions behind the timelines and what's really going on there. But if you have anything, Lacey, most
I don't have much to add besides what you said, that there simply is a lot we don't know about delays and things like that. But I would just really encourage everybody listening to stay tuned and stay connected with David and others that will inform you about when these things happen, and that certainly will want to be sure to provide all of these resources to the Afghans who have come to the United States, and make sure that they have all the resources that they need. So it's an ever-changing space, and we're certainly doing all we can to advocate that these protection mechanisms happen quickly, and that then individuals get all the information that they need.
Absolutely. Thank you so much, Lacey. And that was all that we had for this afternoon for our webinar on resettling special populations, balancing urgency and equity. I would like to thank again our panelists, Lacey, Kristen, and Colleen, for their contributions and for joining us today, and for all of you joining us. I have here the link to the Justice for Immigrants website. This is a great resource for this webinar, which will be posted there, as well as a number of other pieces of information related to Afghans, Ukrainians, and other populations served by the U.S. Conference of Catholic Bishops, the Catholic Church more broadly, and of course, the many different organizations that we partner with, such as IRAP and ICMC. So thanks everyone for joining us, and we look forward to seeing you on the next webinar.